Can I recover more than the at-fault driver's policy? Yes, and there are a couple different ways to do it. I'm going to discuss a few of those methods. But first, we need to understand a few basic rules. Progressive, State Farm, Allstate, and Country Financial are all insurance companies insuring drivers. Their clients are called insureds under the car insurance policy. Now, these companies are the insurers. The document binding the insured driver to the insurer insurance company is the insurance contract, also known as a policy. Every car insurance policy will have a liability limit, and this is sometimes referred to as a policy limit. A policy limit is the most the insurance company, think Progressive, State Farm, Allstate, Country Financial, it's the most they're legally obligated to pay when one of its drivers injures you or damages your vehicle. So the at-fault driver is responsible for the remainder of any damages, unless you can set up the at-fault driver's insurance company. Now, this is known as a third-party bad faith claim. Bad faith against the at-fault driver's insurer is a process where you give the insurer of an insured the opportunity to settle within the policy limits. If the insurer refuses to do so, the insurer can be liable for all the damages beyond the policy limits. The law allows this because it would be unfair to the insured, that's the driver, for the insurance company to essentially gamble with the insured's life, especially when the company can pay the policy limit and resolve the case. So third-party bad faith claims involve going to trial and securing a verdict in excess of the policy limit, usually. In addition, you must have made a demand to settle within the policy limits. In cases where the insurance company fails to respond or otherwise does not settle where the insurance company had an opportunity to settle within the limit, the insurance company can be on the hook for the verdict in excess of those damages or that verdict. So in addition to a bad faith claim, you may have underinsured or uninsured motorist coverage. Most decent insurance policies have what is known as underinsured or uninsured motorist coverage. This is your insurance policy, but you are not suing yourself. Rather, you are making a claim for coverage you already paid for. Just like with the at-fault driver, the insured, and his insurance company, insurer, you and your insurance company have a contractual relationship. And this relationship is governed by the insurance contract or policy. Much like the insurance policy of the at-fault driver, you two have a policy limit. If your policy limit is higher than that of the at-fault driver's insurance policy limit, then you can recover the difference from your insurer. This is known as a first-party insurance claim. Sometimes your insurance company won't negotiate with you in good faith. In these situations, there are statutory damages courts can impose in addition to the recovery you receive against the at-fault driver. So, outside of insurance coverage, the person who is responsible for the damages to you and your vehicle, well, the at-fault driver is personally liable for those damages over and above any insurance coverage. Thus, you can sue and receive a verdict, then collect against any asset that person may have. This includes garnishing wages, seizing property, and generally being a thorn in the at-fault driver's rear. As they say, turnabout is fair play.